So everyone, good afternoon. My name is Jenifer Thien. I'm a council member with Climate Governance Malaysia, CGM. So thank you for carving out time from your very busy schedule to be with us this afternoon. We really appreciate it. It is our belief that investing time in deepening our knowledge on climate and ESG is indeed invaluable. The ROI is going to be incredible. So thank you. It's going to be really worth your time and effort. So I want to also, So I want to also take a moment to thank all of our sponsors, who had made it possible for us to bring the Directors Masterclass. To all of you, thank you. And without whom this today wouldn't have been possible. I want to thank particularly ICDM for the generosity in hosting today's session. We really appreciate it. Thank you. Now, the CGM initiated the Directors Masterclass series in 2023, so not that long ago, actually. And we did it with the objective of deepening the understanding of board directors of critical climate issues and practical skills needed as we are all long-term stewards of our businesses. So within CGM, we are acutely aware that there is a lot of appreciation of why climate transition is important. I think everyone appreciates that. But where we are also acutely aware that there is a need to deepen the knowledge of directors in the what and the how and so on. So basically, it's very important for us to equip the directors, the board directors, with the knowledge and the practical skills so that they are able to bring that back to the boardroom and make the necessary impact. So with that in mind, we have put together the Directors Masterclass series. So the first round of sessions was done last year. Last year there were 7 masterclasses altogether, and this year we had 6 masterclasses, and today is actually the last of those 6 masterclasses. We covered, in the last couple of years, we have covered a huge range of topics. We did deep dives into Scope 3 emission, into biodiversity, carbon markets. We've also done time on double materiality, for example. So this is just the tip of the iceberg. All in all, we had more than 700 attendance across the last couple of years to all these sessions. We're very grateful to have with us, really true and very much leading subject matter experts and also key opinion leaders to lead all of these masterclasses for us. So we are already looking forward into 2025. And we are now in the process of putting together the Director Masterclass series, and definitely we want to make sure that we bring and curate to you and curate a series of programs that will be able to help us to go deeper into some of these very critical topics. So if you have any recommendation or suggestion on areas that you think we should be deep diving into, please do come and see us. So before we start today's class, I want to invite Michele Lim, President and CEO of ICDM, to share some remarks with us. Michele, I'm going to give the floor to you. Thank you again for hosting us today.
Afternoon. Yang berbahagia, Tan Sri Tommy Thomas, former Attorney General of Malaysia, but a very, very old friend and colleague as well. Distinguished guests and colleagues, ladies and gentlemen. I do extend my apologies on behalf of our chair, Tan Sri Zarina, as she is unable to make her way back here in time due to her back-to-back commitments today. Ladies and gentlemen, this is a pivotal moment. Southeast Asia, a region brimming with potential, faces a stark reality, and we all know this: climate change. Its impact is undeniable, And the responsibility for navigating this crisis falls squarely on all our shoulders. Now, as leaders in the boardroom, we are the stewards of our companies. Client Earth, in collaboration with Climate Governance Malaysia and Earth on Board, presents a groundbreaking resource, the Guide on Climate Action for Boards in Southeast Asia. This guide isn't just informative, it's a definitive call to action. The landscape is shifting, regulations are evolving, markets are demanding transparency, and climate risks are escalating. The guide equips us to understand these risks, navigate legal complexities, and integrate climate considerations into our core decision-making. Now, this is no longer just about compliance. Leadership demands setting ambitious climate goals, embracing robust climate disclosures, and engaging with stakeholders. The guide will offer practical insights to achieve this, drawing on the experiences of regional leaders like yourselves. Now, here's the bottom line. Integrating climate action fosters resilience, profitability, and long-term success. Ignoring it exposes our companies and communities to devastating consequences. The guide empowers us to be the change makers we need to be. Now let this be the catalyst for action. Obtain the guide, delve into its resources, and most importantly, lead the change on climate action. Let's secure a sustainable future for Southeast Asia and all of us together. Thank you. I hope you have a very good, productive afternoon.
Thank you very much, Michele. Thank you. So yeah, this is, as Michele said, this is a very momentous development. So let me just take a moment to just mention again that the name of the guide is Guide for Corporate Boards in Southeast Asia on Climate Change, right? And as Michele said, this guide has been developed and is co-published by Client Earth. Client Earth is an international environmental law NGO. Another co-publisher is Earth on Board. Earth on Board is an organization dedicated to helping organizations to achieve an Earth-competent board. And Climate Governance Malaysia is also a co-publisher as well. You know, so this guide, as Michele has mentioned, it provides an overview of net zero transition in Southeast Asia and the resulting shifts in regulations and market expectations. That's at a very high, very, very high level. So in order to give us an overview of the guide, I'm pleased to introduce to you Ms. Kyoko Okuyama and also Mr. Simon Wong. Kyoko is a legal and policy researcher in the Energy Systems Asia teams based in Client Earth's Brussels office. Simon is an independent advisor on governance and sustainability. He's a member of the Sustainable Finance teaching team at the University of Cambridge Institute for Sustainability Leadership. So we are in good hands. I'm going to invite first Ms. Kyoko to tell us more about the guide. Thank you.
Thank you very much for the introduction. As mentioned, my name is Kyoko Okuyama. I am based in Brussels and the legal and policy researcher here at Client Earth, mainly focused in Southeast Asia and Japan. So today I am here to present to you the Guide on Climate Action for Boards in Southeast Asia, launching today. And before I go into the details of the topics covered in the guide, I would like to preface on why Southeast Asia is key for climate action. As many of you may have read in the UN High Emissions report that was published a few weeks ago, there has been a reported 1.3% increase of greenhouse gas emissions from 2022 levels to 2023. And this means that there's a dire forecast of global temperature rise projected to rise 2.6 to 3.1 degrees by the end of the century. This is important in the context of Southeast Asia because it is home to 685 million people, up to around 8.5% of the population of the world, and the aggregate 5th largest economy in the world. This is a negative phenomenon where we see that this region is dependent on fossil fuels. Mainly the energy demand of this region has come from fossil fuels since 2010, and the impacts of climate change are the population is highly vulnerable to rising sea levels, increased heat waves, strengthened monsoons, as you may have seen in the past seasons. If net zero emissions are achieved by 2050, it is noted that the Asia-Pacific GDP may rise by as much as 6%, and that this would create 36.5 million additional jobs by the 2030s. So to preface, Southeast Asia is key for climate action, and this is why we are launching this guide on climate action for boards in Southeast Asia. This guide is co-published by Earth on Board, Climate Governance Malaysia, and Client Earth, and we cover the 5 topics which are listed on the slides before you. The topics are legal duties and risks facing boards and companies, reporting on the climate, the increasing importance of transition plans, shareholder engagement, recent developments such as regulations abroad in the European Union, and climate finance instruments. At the very end, we will cover practical guidelines on integrating climate into the boardroom. So the first topic of climate litigation against corporations. According to a multinational law firm survey in 2024, they showed that the ESG disputes are identified as the top litigation risk facing organizations globally. And this is evidenced by the 230 new climate change litigations filed in 2023. And this report of the annual review of climate change litigations show that there is an increase in the global south. The identified legal risks in the guide that we have categorized into 5 different points are greenwashing allegations, climate-related harm, liability for financing climate-damaging activities, contractual liability, and regulatory enforcement. It is now clearer than ever that directors must lead transition and be literate on the science and economy behind the climate change impacts. It is also now more important than ever that the climate risks be incorporated into business strategies. So now I would like to outline the climate change litigation examples that we provide in the guide. Within the guide, we cover about a dozen cases that have been seen in the past years. And today I would like to highlight 2 cases that we have in the guide where it would be the most relevant to this audience. The first case is Asmania et al. Versus Holcim, which was filed in 2023 in Switzerland. The important point of this case is that this is a very transboundary climate case where Indonesian plaintiffs of a certain island have filed against a Swiss building materials and cement company over the impacts of increased flooding in their region. The 4 inhabitants of the Indonesian island ask for this Swiss building company that they have allegedly breached Swiss civil codes, and they request compensation for the flooding that they have experienced and the businesses affected due to these phenomenons. And they ask for a contribution to adaptation measures and decreasing CO2 emissions rapidly in their business. It is important to note that this case shows that the global nature of climate change impacts shows that there is a higher risk of individuals as well as organizations bringing businesses to responsible actions due to their businesses that are affecting across borders. The second case I would like to highlight today is the Japanese youth versus JERA and others, in brackets 10 thermal power companies, which was filed just 3 months ago in Japan. This is the first ever youth-led Japanese climate case, which targets 10 thermal power companies in accumulation, which emits 30% of Japan's national greenhouse gas emissions. The Japanese youth allege a breach of Japanese tort law, saying that the companies have not protected the rights or interests to life, health, and property that are deemed important in the Constitution of Japan, and they ask for companies to implement emissions reductions in alignment with global emissions reduction pathway. It's important to note that since these 10 thermal power companies are also members of associations coordinating climate action, they have the joint responsibility of decarbonization. And lastly, on the point of legal risks and opportunities in alignment with directors' duties, this is a page taken from the guide where we have highlighted legal opinions in the region that show the recognition of increasing material financial risks that directors need to be much more aware of in the region. To highlight, I would like to show the legal opinion which was written about Malaysia, where they note that directors are duty-bound to proactively and urgently apprise themselves of all aspects of climate change, and that it is no longer possible for directors to ignore climate change considerations as part of their fiduciary duty. Next page. Okay, great, thank you. The second topic that we will cover in the guide is increasing regulatory support for corporate climate engagement. As we have already discussed, increasing regulatory support is growing, especially in Asia, around corporate climate engagement. And this is seen in many of the stewardship principles and code for institutional investors that have been published, not just in Singapore and Malaysia, but also notably in South Korea and Japan. The Singapore Stewardship Principles, revised in 2022, show that if any area of concern remains unresolved, there should be policies in place to escalate stewardship. And the second point for Malaysian Code for Institutional Investors, revised in 2022, show that, in essence, good engagement identifies relevant ESG issues, objectives, tracks results, maps escalation strategies, and incorporates findings into investment decision-making. An example of shareholder engagement is the shareholder engagement we see growing in Asia around the net zero transition. In Asia, the number of companies subject to shareholder campaigns has increased by around 13% between 2022 and 2023, and most of this growth is seen in China, Korea, Singapore, and Malaysia. Engagement has two different categories: private engagement, which can look like holding meetings with companies or conducting investor roundtables, or public engagement, which would be shareholder resolutions at annual general meetings, voting for or against the appointment or removal of directors, and making joint statements with the company. A non-exhaustive example of a climate-related shareholder resolution, as you see in different colors at the bottom, is where shareholders can ask for increased transparency and disclosure, or in the rare case, a demand for disclosure of climate and energy policy lobbying. In Asia, Japan is one of the key jurisdictions where shareholder climate resolutions are growing. Beginning in 2020, there was a Japanese shareholder climate resolution that was brought to Mizuho Financial Group. And since then, every year, there has been climate shareholder resolutions brought to the AGM season. In 2024, 7 companies in several sectors, including banking and utilities, received climate-related shareholder proposals that some of the resolutions received 20% shareholder support. A 20% shareholder result is a significant amount, which is, according to good governance, asking for effective response. A key example of a shareholder proposal in Japan is the one that has been sent to J-Power, which is a large thermal power company in Japan, in 2022 and 2023, led by institutional investors. In this shareholder proposal, they asked for an alignment with the Paris Agreement, aligning capital expenditure with the decarbonization targets, and incentivizing board members with climate objectives. A year after all of these proposals, in 2024, J-Power disclosed a new medium-term management plan, including the closure of up to 5 coal units by 2030. During this announcement, the president of J-Power said, "We deemed it necessary to demonstrate to shareholders our strategy for coal power plants on a site-by-site, unit-by-unit basis." Lastly, on the point of developments and regulations abroad, I would like to cover some of the developments that have been happening in Europe in relation to climate change, which are notably the Corporate Sustainability Reporting Guide Directive, as well as the Corporate Sustainability Due Diligence Directive. They are CSRD and CSDDD for short. And as many of you may think that this is remaining within the European borders, a lot of these directives will be impacting non-EU companies. And it shows that at least 10,000 non-EU companies will be in scope for the CSRD, and approximately 900 non-EU companies are in scope for the CSDDD. The last regulatory development that I would like to talk about is CBAM, Carbon Border Adjustment Mechanism, which will impose additional costs to exports entering into Europe. Since Europe is the third largest export market for ASEAN goods, it is very clear that this region will be impacted by the mandatory obligations required from CBAM. This will be operational from 2026 and initially applying to 5 different sectors, but is scheduled to expand in the future. So thank you very much for listening to my 3 main points from the Guide on Climate Action for Boards in Southeast Asia. Now I would like to pass to Simon Wong, who will cover transition plans and practical guidelines on integrating climate into the boardroom. Thank you.
Thank you very much, Kyoko. Good afternoon. Thank you so much for joining us today. It's great to be back in KL. It's been at least a decade, I think, since my last visit. And I actually spent part of my youth in a little village outside of Medan. So I'm from the region, even though most of my life has been spent in the West. I'm going to be talking about the last section of the guide, which is integrating climate into the boardroom. And it has a different feel to the rest of the guide because it's based a lot on interviews with different actors in the region. Just to give you a sense, a little more background about this strand of work. The genesis came out of a discussion with a Client Earth colleague in London in late 2023. And we thought that providing examples of climate action leadership from the region would resonate more with the audience. And also hopefully will inspire and guide more ambitious climate action in the region. In terms of gathering information, not yet. Thank you. In terms of gathering information, we thought that speaking to people, interviewing people, would also lead very helpful insights. And sure enough, we were fortunate that nearly 24 people, including Sunita and Philippe, kindly and generously gave us their time. The other people we spoke with included founders of large companies, board directors, senior executives, sustainability specialists, institutional investors, bankers, and external analysts from different countries in the region. From these discussions, we learned about how corporate climate action journey evolves over time. And you will hear me say this a few times, it's a journey, right? No one gets it right the first time. And it's about learning and experimenting. And the second part is you see the growing willingness of companies and their leaders to experiment and learn. And third, I learned about the institutional and personal values that motivated these companies and these individuals and these leaders to take action. So my part of the presentation is to share these findings. Now Now we're ready. Okay. This chapter of the guide has two sections. One is, how does the board structure itself? And the second is, what the board should focus on in terms of overseeing climate mitigation, climate transition. I think this could be made available to the audience afterwards, so you don't have to take pictures, but feel free if that's more convenient for you. To effectively lead on climate transition, we believe that it's important for boards to be formally charged with overseeing climate action. And this is happening globally. And in the region, Professor Mark Thien of National University of Singapore published a survey last year. And in the survey, he found that 87% of Singapore and Malaysia's 100 largest companies, 50 in each country, have formally embedded sustainability governance into the responsibilities of the board and board committees. By way of comparison, a 2022 study in the US showed that 92% of S&P 100 have a clear sustainability mandate. Of course, there are variations in board mandates, with some giving climate governance considerable prominence. Here I wanted to share the case of Ayala, which in conjunction with a commitment that it made in 2021 to achieve net zero by 2050, changed its board charter and elevated climate governance to one of the board's 4 principal responsibilities. I also wanted to share Unilever because you can also see another example of how precise some of these board mandates are. In this case, endorsing and amending the climate transition plan of the company. Because 85% of large businesses in the Asia Pacific are owned by families, and some other ones have the state as major shareholders, the guide also emphasized the importance of securing a de facto mandate from controlling owners to enable the board to effectively lead. This is just the reality. Yeah. Referring to family firms, one interviewee quipped, "If you don't convince the patriarch, nothing will get done. But once it is supported by the family, it is implemented, and it is implemented fast." Oops. Great. Oh. I just want one. Okay. Corporate boards across the globe adopt different structures to oversee sustainability matters, with some assigning to the full board, while others delegating to one or more board committees, including a standalone sustainability committee. In Southeast Asia, a dedicated board-level sustainability committee is not yet widespread. According to Professor Mark, 11% of Malaysian and Singaporean companies have a standalone board-level sustainability committee. This is among the 100 surveyed, 50 in each country. And with another 13% featuring a board-level committee that is tasked with overseeing sustainability as well as other matters such as safety and risk. By way of comparison, 51% of the FTSE 100 has an ESG or sustainability committee, while 15% of the S&P 500 have a similar setup. There's concern that a standalone sustainability committee may become siloed and that it might be better, therefore, to spread responsibility across different committees. From the interviews conducted, I was persuaded about the benefits of a dedicated committee, particularly to devote adequate time to overseeing climate transition. 3 points were stressed to me in my discussions with different people in this region. One is that with a dedicated sustainability committee, you have more time to discuss critical issues. A few interviewers talked about prior to the establishment of a sustainability committee, sustainability's topic often sat at the bottom of board agendas. And discussions were often rushed because other topics, the preceding topics, overran. Second, these critical issues can be quite complicated and technical. For example, measuring Scope 3 emissions. I think you guys discussed this in prior master classes. Debating transition pathways to net zero, or setting targets in connection with validation of net zero commitments, or with the SBTI validation process, SBTI Science-Based Targets Initiative. And the third reason is, once formulated, net zero transition plans will necessarily require updating to reflect technological developments, changes in policies, changes in the industry competitive dynamics. So for these reasons, I think that there is a case to be made for a sustainability committee at many companies. A key question that we wanted to ask and we want to explore was how boards build its knowledge and competence to effectively lead on climate action. To provide you with an anchor, the 2024 ASEAN Board Trends Report revealed that 58% of director respondents felt that their boards needed more training on sustainability, climate change, and ESG. I've seen similar statistics in other jurisdictions. So I think there is a general feeling that boards need to do more in terms of building their knowledge and competence. From our research, activities that Southeast Asian companies undertake to equip their board with sustainability knowledge include periodic briefings by internal and external experts, ad hoc participation in educational programs, as well as more systematic training. CIMB, for example, established a sustainability academy a couple of years back. And one of their activities is training 500 board directors and executives across the group. I want to emphasize, though, that enhancing the board's knowledge and competence, it's not only about giving them facts, conveying facts, and passing on technical information, but it's equally about making boards comfortable with experimentation, with making trade-off decisions between short-term and long-term financial returns, or balancing corporate and societal objectives, and with leading their company's climate transition despite unusually high degree of uncertainties involved. Turning to the board focus, where should the board focus its efforts? Just checking my time. It goes without saying that the first step for boards in order to devise an appropriate decarbonization strategy is that they need to understand their company's carbon footprint. And this encompasses direct scope 1 and indirect scope 2 and 3 GHG emissions. Important categories of information to gather include aggregate volume, types of emissions, and main sources of emissions. The guide goes into a bit further about the utility of procuring a full inventory, but I'll just leave it at that. If you want more information, please consult the guide. Several interviewers noted that in Asia, sustainability and climate change are treated principally as compliance issues rather than as a strategic matter. But what's interestingly and quite illuminating for me was that the discussions we had revealed that applying frameworks such as TCFD help Southeast Asian companies not only identify and deepen their understanding of climate-related risks, but also they found opportunities to reduce costs, introduce new products, as well as gain useful insights into making capital allocation decision. For example, a risk executive at a Thai financial institution shared with me that the application of the TCFD framework helped to bring a more structured approach to measuring and implementing sustainability across the group, and also facilitated cross-pollination of product offerings, such as extending EV loans from large corporate borrowers to SMEs and consumer clients. Similarly, the audit committee chair of a Southeast marine communications service provider shared with me that the results from TCFD-driven scenario analysis helped them with their capital and technology investments over the next 5 to 6 years. As with other aspects of climate transition, the assessment of climate risks and opportunities is a journey. At one Hong Kong-based company, They spent year 1 analyzing physical risks on major assets. They spent year 2 analyzing transition risks using under low and high emission scenarios, and worked on more robust risk assessment methodologies. And they spent year 3 on risk mitigation to help bolster their resilience. Okay. I will have other slides. In terms of level of ambition on climate action, more and more large companies in Asia and elsewhere are making commitments to achieve net zero. According to Net Zero Tracker, of the world's largest 2,000 publicly listed companies by revenue, 37 East Asian companies and 58% of Southeast Asian companies on that list have committed to achieving net zero. Some Southeast Asian companies go further in their net zero commitments by adopting science-based targets and submitting them to SBTi for review and validation. In this group includes SD Guthrie and Sarawak Energy of Malaysia, GoTo Group of Indonesia, Globe Telecom in the Philippines, CDL, Singtel, and StarHub in Singapore, Siam Cement, and Thai Union in Thailand. I know the list is longer, so I apologize if I don't mention any of your companies. I think what's also important to know is that once a commitment has been made, companies are increasingly expected, and in Europe, will soon be required to formulate a net zero transition plan. This will set out how the company will deliver on its commitment over short, medium, and long-term timeframes, covering operational changes, capital expenditures, product and portfolio composition, governance, and other significant matters. There have been different initiatives to help guide companies on delivering net zero commitments. This is one of them, which is the Transition Plan Task Force Disclosure Framework from the UK. And I share this because this is gaining traction globally. ISSB has decided to pick up on this work and continue and to develop educational material to guide companies globally. And these are the main pillars and elements of the TPT framework. What I want to just emphasize, because you can read about these on your own time, is the overall theme, which is that decarbonization should not take place in isolation, but should contribute to an economy-wide transition. And the TPT warns against what it's called paper decarbonization, which is simply transferring ownership of high carbon assets to other actors in the system, who may be less well-placed, I'm quoting them now, to bear the risk or phase out their use, and that this can be counterproductive to an economy-wide transition. Our research has found that a detailed and comprehensive transition plan is relatively rare among Asian companies, or Southeast Asian companies, although we came across higher-level roadmaps, and for financial institutions, sector-specific transition plans. The one that was most detailed that we came across came from AIA, Insure AIA, based out of Hong Kong. And I want to share this case because I thought it was quite instructive. So one, AIA also subjected their targets to SBTi validation. And second, its disclosure, its transition plan follows the TPT format in part. What I thought were notable was segmentation of discussion by operations and investments, including drawing on sector-specific pathways for power generation and real estate. And then a more detailed discussion of the key levers for achieving their 2030 targets. They also, I thought, helpfully provide an assessment of progress made and next steps on different dimensions, including integrating climate risk into decision-making, governance, internal and external engagement, and integrating sustainability beyond climate action. Here they're referring to nature, biodiversity, and just transition. Again, it's a journey, right? It will evolve their thinking, their action, their plans. And lastly, they provide a helpful description of how different types of transition and physical risk will impact the institution as an underwriter and as an investor. I think I need to wrap up. Oh yes, one thing I want to do that's important when we're talking about transition plan. They're underpinned by significant assumptions, all of them. So AIA talked about how its ability to decarbonize its operations depended on a variety of factors, including the availability of green real estate, access to renewable energy, and the maturity of EV infrastructure in the diverse geography in which it operates. I want to share another slide. This is Japan Airlines, and this was shared at an event last month in Tokyo. And what jumped out for me in terms of how JAL is envisioning its path to net zero is how much it is relying on immature technologies to get it there. And the activities under its direct control, that thin line basically, reduction in daily operation, constitute just a tiny sliver of total decarbonization needed to arrive at net zero. I say this because to different degrees, transition plans will have similar assumptions, and therefore for boards, it is really incumbent on boards to review key assumptions periodically for their relevance and robustness. And even after a transition plan has been approved, these are living documents, as I mentioned earlier. They will require periodic updating to reflect technological development, changes in policy, in the policy environment, but also a company's deepening experience in terms of transition. So TPT, for example, said that it expects progress in certain areas to take time, such as how entities map and engage with their supply chain, how they quantify the financial effects of the plan, how they integrate consideration of climate adaptation. Okay. Last two things we discussed in this section of the guide is just alerting the board of the importance to ensure there's alignment within the organization. This means within the boardroom, between the board and management, between top leadership and the rest of the organization, and between the company and its value chain. The guide provides more details if you're interested in learning more. And the last thing is that the guide also talked about different tools that are at the board's disposal to help ensure that climate transition stays on track. And these include incorporating climate-related KPIs in executive remuneration, adopting an internal carbon price to guide different types of operational and capital allocation decisions, drawing on climate finance tools such as sustainability-linked loans and bonds, and lastly, procuring external insurance to increase robustness of data collection and disclosure. I'm going to stop because I think I went way over time. Thank you so much.
Now to the next program for us is a panel, and to help us to explore the topic of corporate boards and climate action. And we have, as you can see, a very esteemed, very experienced board with us. We're very lucky to have with us Elizabeth, Tan Sri Tommy, Philippe, and Rejina. I'm going to invite all of you to come on stage now. And while you take your seat, I'm going to do a quick introduction of Elizabeth. Elizabeth is an international economic lawyer focusing on the role that law can play in driving sustainable development. She's a legal consultant and an international environment law NGO with international environment law NGO Client Earth. She's also a global fellow with the Center for International Law at the NUS, National University of Singapore. And she's also a visiting researcher with the Asia Pacific Center for Environmental Law at the NUS Faculty of Law. So thank you very much, Elizabeth. And I will leave the introduction of the panel in Elizabeth's very good hands. Thank you very much.
Thank you so much, Jenifer. And thank you everyone for coming on a slightly sleepy afternoon to listen to the launch of our guide. Can we have a big round of applause again for Kyoko and Simon, who have presented the content of the guide. We are so excited, and Client Earth is so honored to be partnering with Climate Governance Malaysia as well as Earth on Board for the launch of this guide. And we hope that the marriage of legal analysis as well as more practical aspects from the industry will make this hopefully useful and beneficial guide. So without further ado, I'm going to announce the very esteemed panel that's going to be discussing, I think, some reflections that arise out of the guide. We have Tommy Thomas, who honestly needs no introduction. He is recognized as one of Malaysia's, if not the region's, top litigation lawyers. He was a former Attorney General of Malaysia, has served on the Bar Council for over a decade, and is a prominent figure in corporate commercial litigation as well as public aspects of litigation. He's a consultant in his firm, Tommy Thomas Advocates and Solicitors, and really interested in hearing on his reflections on the legal and litigation risks that arise out of climate-related and sustainability matters. So we also have Ms. Rejina Rahim, who is Advisor, Institutional Investors Council. She has over 25 years of experience in the Malaysian capital markets and was the founding MD for the Malaysian office of Nomura Asset Management. She is one of only 3 Malaysians listed in the inaugural 2021 listee of the Kindness and Leadership 50 Leading Lights Asia Pacific, and was also named by Asia Asset Management magazine as 25 industry leaders of the Asian asset management industry. She is the founder of Wahine Capital, which is a means of helping women gain financial confidence of themselves, and she sits on various boards and advisory committees as part of her giving back to the capital markets. And of course, we have Mr. Philippe Joubert, who also really needs no introduction. He is a founder and CEO of Earth on Board. He is a senior advisor of the World Business Council for Sustainable Development, a member of the advisory board of the Cambridge Institute for Sustainability Leadership, and a fellow of this institute. He is an advisor to several CEOs of leading global companies and sits on several boards. And he was previously president of Alstom Power and deputy chief executive officer of the Alstom Group. So I'm very excited to be hearing from this panel of very esteemed experts. And I think to kick us off, I'm going to start with Tommy. And I'd just really be interested in some of your reflections on one of the cases that Kyoko has pointed out that was referred to in the guide, and this is the Holcim case where Holcim was sued in Swiss courts by Indonesian plaintiffs. Now, do you foresee a rise in cross-border litigation on the transboundary effects of harmful corporate activity, and really how should corporations and directors respond to that, given that there are conglomerates with multiple activities throughout Southeast Asia?
Yes, thank you. The Holcim case, the facts were set out. Essentially, 4 Indonesian plaintiffs, individuals, sued in the courts of Switzerland against a Swiss multinational, a company which does cement making and is a great emitter of carbon. They had a choice of, when you think about it, they could have sued in Indonesian, in the courts of Indonesia, because that would be the natural forum, because the island that was affected by high sea levels is an island called Pari. I've never heard of it, it must be a small island, but it's part of the Indonesian archipelago. So one would have thought the first choice would have been the courts of Indonesia, but they chose to sue the head office of the multinational company. Also, and of course, Switzerland has jurisdiction. And I think, of course, the case is pending, so we don't know how the case would unfold. But of course, Switzerland is also the place where they had the famous European court Remark case a few months ago. So I guess the Swiss courts are aware of their responsibilities, and I would expect them probably subject to the strength of the Indonesian plaintiff's case to hold the Swiss government, the Swiss company responsible. Now, is there a trend? A bit difficult. I think, first of all, let me say it's a bit difficult to generalize about Southeast Asia because your subject is Southeast Asia. To remind you, there are 10 countries, at least 10 countries in ASEAN, Southeast Asia, and there's Hong Kong, in a sense, part of Southeast Asia. So it's really impossible to generalize because we just don't have the figures. So I will take a much less ambitious route and comment about Malaysia. I think as a general statement, climate litigation in Malaysia is much quieter than other countries. For whatever reason, it has not taken off in the sense that was identified under the risks, which are really very climate orientated. Of course, you could argue that when there is a flood or there's a factory A carrying out dangerous pollution and undertaking terrible businesses, emitting smog and whatever, and it goes across the next few properties, there is a possibility of litigation. But if that happens, and that has happened since Merdeka, that would be, in legal terms, what would we call a private law action under common law, and they would be relying on cause of actions like nuisance and Rylance and Fletcher and Donahue and Stevenson and negligence, all the old causes of action in tort. And I say that because we still don't have a dedicated climate action bill or anything to do with climate, although there is talk that there's going to be a bill soon. Let us see the bill in the first place, and then if it becomes an act. So I would say that as a general statement, climate litigation is very quiet in Malaysia. And I would say it's not really a fault of the courts or the lawyers, because we come at the second round. I think for some reason or whatever reason, litigants are not keen to rush to court. I don't know why. So of all the directors of boards who are present here, and if you were thinking that you are going to be potentially a defendant in a action, I think you don't have to worry too much, because there's not that much litigation so far. Of course, people like me who are litigation lawyers, we want litigation, but it's a bit difficult to have litigation unless you have clients and parties and litigants. So as a litigation lawyer, I'm always looking forward to a litigant and a client. But that's comfort for board members. And of course, as you know, from a company law point of view, the decision to sue, that power vests with the board. It's not a shareholder decision, it's typically a board decision. But your question, and I've not really answered the second part of your question, that whether trans-border, I'm cynical again. I always give the example of the smog. I mean, let's use the words. For the last 30 years, we've had, in August, September, and October, a haze in West Malaysia caused by burning in Sumatra. So they've been burning in Sumatra, whether it's oil palm estates or the forest or whatever, jungles, whatever, including Malaysian companies apparently, for 30 years. And for 30 years, the smog crosses the Straits of Malacca, comes to Malaya, comes to Singapore. But because Indonesia is abang, Singapore and Malaysia would make pious platitudes saying, oh, we must have conferences and whatever. We have any number of agreements, but nothing has happened. That's the reality. Of course, that's a national issue. We could litigate, anybody could litigate actually in anywhere. You could litigate in Singapore, the Singapore courts, the Malaysian courts, Indonesian courts, probably in some international forum. But it does not happen. But that's at the national level. Insofar as private sector is concerned, again, you don't have the statistics, but I don't see any reason why it can't be done. It can be done. So that's what I would say.
Thank you so much, Tommy, for those reflections. So I think those are really interesting observations, and maybe just to understand from the perspective of directors and boards, I'm going to turn to Philippe now, and of course understanding as well that the fact that a litigation hasn't actually occurred in a country doesn't mean that there isn't increasing legal risk. I think it's quite clear also from the discussion so far that there is an understanding of obligations of directors' duties and how all of this works out. And so turning to Philippe then, both from the perspective as, with your experience with boards, to guard against legal risk, but also for a corporation to be competitive, how should the corporation factor climate change and the protection of nature into its systems and processes? If you can use the microphone. Yeah.
What I think is important is perhaps to come back why we are here talking about governance. And then I can answer your question. Yeah. Because governance is not something that is a dry subject coming from nowhere. Governance is about repartition of power and responsibility in a company. So it's a very, very deeply inside the purpose and the way we work. That's the way I want to look at governance. So when you look at the business model that we have been doing and respecting for years, we are making business taking nature for granted and unlimited. That's the way we have generated profit so far. Because all the rest about value creation is nice, but it's not the reality. We are not paying the bill to nature. So that's the number one. So your question is about, in reality, how do we start changing this? Because as long as we are making decisions, and governance is here for that, on wrong assumption, like nature is free, nature is unlimited, we can talk governance forever. It will never change. So the reality is, if we want to maintain capitalism as a way of developing business, and why not, we have to put inside the machine the reality of the number. And then come your question, because I have seen some example here of companies that are not respecting this basic principle. We have to pay for the reality of the cost factor we are using in our production. And then the investor can be comfortable in investing, and the customer comfortable in buying, because we are based on reality, not dream. So you have to use some techniques like shadow price or, by the way, just to conclude, is if I defend the idea, and this is not bulletproof against very astute lawyer, but I defend the idea that a board that approves an investment intensive in carbon, like a power plant, and has not put in the evaluation of the cash flow a shadow price of carbon, could be, sometime down the road, be qualified as negligent. Because doing this, they have built potential stranded assets. And investors are invested in this company on wrong basis. So to summarize your question, I will just give this example that for me, put back governance as a real issue and live issue. And after that, I can continue on this.
Sure, thanks so much. So actually I want to get the view from Rejina on investor pressure, but just before I go there, picking up on what you said, there is maybe fears of corporate greenwashing, and I wonder whether you can comment, on that, and maybe that can itself be a 1 hour section, but just briefly perhaps.
On greenwashing.
Yeah, on greenwashing by corporates and how.
You really like to put me on the spot.
Yes,
huh?
I do,
okay.
yes, yeah.
Nice, okay. We had very good example of some in the table. How come a board can approve a plan like the Japan Airlines one? How come he dare to say this is a transition plan? All this technology doesn't exist. They are at the level of very, very small parts. We don't have enough land to fool the airlines with this kind of. So this is a perfect example where somebody dream about a transition plan based upon technology that doesn't exist, and the board approved that. So for me, this is also why you have a very bright future as litigation, because this, for example, will prove wrong, and board will be in trouble very soon.
Hey, thank you so much.
But if you want other example, I have plenty, because, for example, these guys, they are now in fuels, in SAFT. Huh? They were before in planting trees. Huh? Remember, all the airlines were going to net zero planting trees. I mean, this is a shame.
And by the way, in the guide, there are also examples of greenwashing, and one of the cases against KLM, greenwashing by KLM, is in the guide as well, and Client F also supported that case. So let me move to Rejina, and be really interested to hear your views on the role of institutional investors in scrutinizing climate-related activities of corporations in Asia, and how institutional investors can create pressure. So there were some examples that were raised regarding shareholder climate resolutions in Japan, and I just like your reflections on institutional investors' role in this space, and maybe also how you see this developing in Malaysia.
Thanks, Elizabeth. Well, sitting with these two gentlemen here, I think I'm actually very, very scared, both for the fact that I personally believe there will be a lot more litigation going in Malaysia because of the fact that I think there is cases of greenwashing. I think, let me just share with you a few statistics. Yeah, so we, Malaysia alone in terms of GHG emissions is less than 1%. So a lot of people think it's not important. But if you look at it collectively within ASEAN, we have less than 4% in terms of GHG emissions. However, if looking at the climate change, that we are going to proceed at 2 degrees, what that means is that about 14-15% of our GDP within ASEAN will be wiped out because of climate change, right? And then you add on to that the fact that on Bursa Malaysia alone, we've got 1,049 companies. Based on what the SE has said, about half of that have actually sustainability committees. Then you add on to the fact that you've also got Bursa's listing requirements, whereby from next year onwards we'll be having a lot more reporting in regards to sustainability and all that. Basically what I'm saying is that we have no choice. As investors, as PLCs, you need to make sure that you are adhering to the requirements. Because if you look at it, if 70% of our entire companies are actually exporters, and the fact that you've got your CBAM, you've got your EU disclosure requirements, you've got TCFD and all that, in order to be sustainable in the long term, then we go about financial resilience, right? You're going to have to be able to meet those requirements. It's something that we just can't move away. So if you look at the IIC, which was also mentioned by the earlier speaker, at which point we talk about the MCII, which is the Malaysian Code on Institutional Investors. Principles 5 and 7 talks about sustainability, right? So we've got 38 signatories, which basically covers most of our members, and that covers 2.3 trillion ringgit, right? So we move the market. Our members move the market. We've got EPF, we've got COP, and we've got PNB. PNB, for instance, has written a letter to all their investee companies that if they do not have a net zero target for 2030 or beyond, at which point those companies will be divested. So it is crucial. We've got to do it. There's no turning back.
Thank you so much for that. May I just follow up with another question on whether you think regulators are doing enough or should be doing more? And maybe from the perspective also of bringing other stakeholders besides just shareholders into the conversation. Is that a role for regulators at all?
There's always a role for regulators, because also you must remember in Malaysia, we also have a massive power distance. So whatever it is, as long as the regulator says go, we'll go, right? Because that's how the mindset is. So if you don't have the regulator saying these are the minimum standards, as well as the institutional investors are not saying do this, otherwise we don't invest in you, nothing will change.
Okay, thank you so much. So I think maybe moving then from regulators to governments as a whole, because one other development that's been occurring globally is lawsuits against governments related to climate. So this guide is focused on boards and corporates, and so it covers lawsuits against corporations, but also separately there's a category of climate litigation which involves lawsuits against governments, most recently in Korea, where the Korean Constitutional Court has ruled that the Korean government's plans regarding net zero transition are partially unconstitutional. And so I just want to turn over back to Tommy and ask you what your views are about how a potential rise in lawsuits against governments around the world actually informs the manner in which corporates and directors in Southeast Asia should take action regarding legal risk. Not just because litigation against governments might affect regulations that governments promulgate and also have a different sort of shifting legal climate for companies and directors. It'd be great to get your views on that.
Yes, if I can start with the Korean case. In the Korean case is an example where there were about 250 plaintiffs, including some young people, sued and that sued the government of Korea, and that's again pending in the courts. But there has been some ruling whereby they said that the government of Korea had breached the constitutional rights of these plaintiffs, individuals, and the constitutional rights that were being affected, according to the court, was the right to have a clean and healthy environment and to live in prosperity, which is quite unusual. Now, and as a result of that, the Korean courts ordered their parliament, which is their National Assembly, to bring up within 2 years some kinds of targeted laws and requirements for a 20-year period. So it is quite creative. But that is nothing unusual. I mean, I know they made a fuss about Korea being the first, but not really. The courts of India were quite advanced even decades ago. And I say India because the Malaysian constitution on fundamental liberties is taken from India. So both Malaysia and India have an article called the right of liberty, personal liberty, and the courts have construed the two words personal liberty to include the right of all of us to have a clean environment, the right of all of us to have a healthy environment. So all of us have that constitutional right. And of course, when the governments don't comply with it and break it, then of course they are vulnerable. And of course, if the governments are sued, then in a sense it's public law, and to some extent it's more difficult to establish, because that comes back to the second half of your question about companies, which is what most of your guests participants are interested in. The threshold to sue companies, corporations, private bodies for these breaches is much easier. And of course, pending some written law, you have to go back to common law actions. And there's no reason why you can't invite the courts to use the old tools of what I said, negligence, Rylance and Fletcher, Donoghue and Stevenson. And the other thing is, I think, one of the developments everywhere, and I'm sure the Malaysian courts would follow that, if the Malaysian lawyers invite them, which is to say, look, we mustn't just look to the typical countries that we follow, which is England, Australia, India, the common law countries, because we should look to developments all over the world. So for example, why not the Korean case? Why not the Swiss case? And of course, European Court of Human Rights and all those. So that is definitely something that will happen if litigation in our courts on this area increases.
Okay, thank you so much. I see that Philippe would like to comment.
Yes, because I think this is really an important point. You know, I spend my life going from board to board and discussing with them and trying to convince that they have to change. And when I arrive at the level of the agreements, like the Paris Agreement, the first reaction is, but this is not binding, so this has no value, and we don't care. Then what you just explained is absolutely fundamental to make a change in behavior in the boardroom, because if we really strengthen the responsibility of the government that have put this in their ordinary law, this gives to the Paris Agreement the whole strength to be considered as a real thing by the business. And you know, we sometimes discuss with clients, the business doesn't react to fact. Business react to expectation of fact. So even if you don't win a case in a court, the fact that you have been suing bad behavior and showing that there is a probability that he could lose next time, you change the behavior. So I think what you explain about this whole architecture of responsibility, starting at the country level, is absolutely fundamental if we want to reach the boards.
Thank you.
Yeah, can I just say, in Paris, the Paris Agreement, I think Malaysia follows a lot of the common law countries, which is that our parliament must pass an act of parliament, whereby, and typically they have it as a schedule, where the schedule will say that the Paris Agreement has now become the law of Malaysia. And we suspect that the bill may do that. The bill may do that, and then when that happens, then the Paris Agreement has domestic for strength and is a part of the municipal laws of Malaysia.
Okay, thank you so much. I think in the interest of time, unfortunately, we have to close this panel. And so I'm going to first thank all the excellent panelists. If we can give them a big hand. And also, thank you, audience, for being such a wonderful and engaged audience. Really appreciate it. I'm going to turn the time back to the host. No, actually, to Datin Seri Sunita to say a few closing words.
Thanks so much. Wasn't that a great round of speakers, right? They were fabulous. Thank you, everybody. So as Poe said, climate change is a serious matter. I'm sure if you have children, grandchildren in your house, they are going to agree that net zero 2050 is to limit warming to 2 degrees by the end of the century and to keep pathways open for 1.5 degrees of warming. Not many people might realize that we are already at 1.65 degrees of warming as at October on a monthly basis, and the 2-year running mean is already at 1.5 degrees of warming. So this might be the first full year that we have 1.5 degrees of warming. The International Energy Agency's energy outlook for this year says that Southeast Asia, a net exporting region, is going to be the second largest region in terms of growth of energy demand. So we have an outsized responsibility to act. And this massive body of frameworks, regulations, climate litigation that we've just been talking about, including, of course, the United Nations in July 22, recognizing for the first time that everyone, anywhere, has the right to live in a clean, healthy, sustainable environment. All of this is reflecting society's insistence that businesses who are profiteering by destroying the environment and polluting the environment, what was called bad behavior, must be held to account. This is the social license to operate that all businesses now have. So directors' duties as a boardroom that directs the company extends beyond shareholders to the community, to the environment, as part of their fiduciary duties. As Philippe said, transforming from shareholder primacy to stakeholder economy, reshaping of this transition economy has tremendous value and opportunity. And institutional investors, we've heard, are on notice to escalate stewardship with their portfolio to have better informed decision making. As we have seen just in the last few months, within a few days of extreme weather events like flash flooding, you are going to have people rioting on the streets with guns. And so every boardroom needs to incorporate climate risks, including litigation, into their business strategy. And how are they going to do this? So ISSB standards, of course, are leading to decision-useful disclosure, which are helping to drive capital to the right place. But are TCFD reports just becoming transition plans without changing anything? Is there a danger of greenwashing? Are we really comfortable with many of the significant assumptions? Are we relying on technologies, as we have heard, that are simply not mature? Are we relying heavily on offsetting? Shadow pricing might be considered diligence. We all have a role in making this more than a tick box exercise. And this is where the engagement strategy with your value chain, with industry, with public sector, with civil society is critically important. And of course, this is where CGM has an important role to play as well. Remember, there is no resilience without ecosystem resilience. We've heard this afternoon from a fabulous panel of speakers. Thank you so very much for your time. I'd like to invite you all to next week's COP29 virtual program. We're supporting the programming in Baku. We want this to be inclusive. We want you to hear from multiple voices, so please sign up for this. Sign up for our newsletters, and please help us to improve by giving us your feedback. Another round of applause for our great speakers this afternoon. Thank you.